Rule 3.8 sets forth some special responsibilities or ethical duties for prosecutors. And subsection E, that's 3.8E, is specifically about kind of a dirty trick that prosecutors might try to play of issuing a subpoena to have defense counsel come often to a grand jury proceeding or maybe at the trial to testify and reveal things about their client. So as you might imagine, there's a rule against this, and that's what we're going to talk about in this video. I'm Drew Stevenson. This is for my professional responsibility class. Let's dive in. Okay, so here's the rule itself. Rule 3.8E says, prosecutors shall not subpoena a lawyer in a grand jury or other criminal proceeding to present evidence about a past or present client unless the prosecutor reasonably believes, and then it's going to set forth some factors or exceptions. The first is that the information is not protected from disclosure by any applicable privilege. So you're going to need to learn to kind of work with this rule in conjunction with the attorney-client privilege doctrines. But let's keep going. Second, and there's three of these, the evidence sought is simply essential to the successful completion of an ongoing investigation or prosecution. And three, there is no other feasible alternative to obtain the information. Now, these are ands, not ors. In other words, it's not just enough that there's a privilege exception that might apply. It also has to be essential information. In other words, there's no other way the prosecutor could get this, and there's no way that they can kind of do their job without it. There's one comment about 3.8E in the comments to Rule 3.8, and I have it here. Paragraph E is intended to limit the issuance of lawyer subpoenas in grand jury or other criminal proceedings. This would mostly occur in the grand jury because in grand jury proceedings, the exclusionary rules and a lot of the other rules of evidence are relaxed. And so anything where there's a situation where there's a genuine need to intrude into the client-lawyer relationship. So again, it's a pretty specific rule, so it should be easy to remember that if you have a prosecutor basically issuing a subpoena to the defense lawyer, you should have a red flag go up. Wait, we have a rule against that. And then you need to look for, again, these factors that we talked about, that the attorney-client privilege doesn't apply. And if you have a test question, it's probably going to be because of the crime fraud exception or something like that to attorney-client privilege. And it's essential to the successful completion of an ongoing investigation or prosecution. And there's really no alternative to obtain the information. It's not enough that the prosecutor says, it'll take us a while to get this information, or it'll be a hassle to get it. There really has to be no other way to get the information. Okay, just a couple notes for when you're in practice. This rule, to be honest, is rarely, if ever, invoked in disciplinary matters. It does come up sometimes in the course of criminal proceedings when we have someone issuing a subpoena and we're objecting, basically no privilege applies, or there's sanctions or contempt proceedings for not cooperating with discovery, and so forth. Okay, that concludes our brief lecture about Model Rule 3.8E.